Today I'll be discussing paper 1 of the patent agent examination of 2018. So paper 1 is generally the easier one out of paper 1 and paper 2 because it directly deals with the sections and rules. So you need to quote the sections or the rules that apply to a particular situation. And so this requires you to be thorough with the section numbers and the rule numbers and what are the basic ingredients of those particular sections and rules. So paper 1 would generally have multiple choice questions for which you need to take the relevant answers. Part A has one option which is correct out of all the given options. However, this pattern may change, but one thing is for sure that the paper 1 would always deal with the particular sections and rules, and so you need to remember the particular section numbers and rule numbers for each particular situation that is being given in the question. So coming to part A of the question paper, it deals with a particular situation wherein patent invention is being acquired by the government for public purposes. So this is provided under section 102 subsection 1. I'll be making a detailed video in this respect, but this particular section provides that whenever the central government wants to acquire a patent, it has to give a notification in the official gazette. Question 2 relates to an exception provided under the publication provision. So patent application would not be published only when there is a secrecy direction that's been imposed, or it has been abandoned under section 9(1), or it has been withdrawn. So all these situations are provided under section 11A subsection 3. Question 3 deals with foreign filing permission. I have already made a detailed video in this respect, section 39. The question asks you to provide the time frame within which a controller is required to dispose of any application that you file at the patent office, and this is provided under rule 71 sub rule 2. So within 21 days of filing of the application seeking permission, the controller has to dispose it off within 21 days. Question 4 is a very general question. As you are all aware, a patent has a territorial right. So whenever a patent is awarded by a patent office in India, it would be valid only in the Indian territory and nowhere else outside India. Question 5 is a trick question. It says that a PCT application has been filed on 19 September 2009 taking a US priority, but it has not provided the US priority date. So the question is specifying that you have to file the national phase application at least before that date. You cannot go beyond that particular date. So rule 20 sub rule 4I provides that a national phase application is to be filed within 31 months from the priority date. Now here you are not provided the priority date as such, but if you count 31 months from the PCT application date, which is the 19th September 2009, you arrive at 19th April 2012. So this is the maximum limit. Suppose the US priority application was filed on the same date as the PCT application, then the 31-month period would be obviously counted from 19/9/2009. But even if the US priority application was filed some days before or maybe some months before the PCT application, in any case your upper limit for filing would not go beyond 31 months from 19th September 2009. So that is the uppermost limit after which you won't be able to file the national phase application. But this is a trick question. Always remember that the 31-month period is always to be counted from the priority date. But since here the priority date is not provided, you have to in a way specify the uppermost limit from whatever date you are given, which is the PCT application date. If you are still confused as to how the 31-month period has been arrived at, please let me know. I'll explain it again. For answering question 6, please remember that a patent infringement suit can only be filed once the rights have crystallized, which is only after grant of patent, and this is provided under section 11A subsection 7. So a patent infringement suit can only be filed after grant of a patent application as per this. Question 7 relates to compulsory license. I have already made a video on that. You could refer to it. This information is already provided in that particular video. The first compulsory license in India was granted to Natco Pharma, and enough material is available online to confirm this. So for question 8, a method of committing theft is an activity which is against public order. So this act would not be considered as a patentable invention, and this would be prohibited under section 3B. You can check the language of section 3B. It says that any invention which is contrary to public order or morality would not be considered as a patentable invention. Question 9 deals with patent of addition. The details are provided under section 55. Now a patent of addition is an extension of the existing patent, so the priority date is considered as the same as the main patent application. So the 20-year period would be counted from the date on which the main application was filed. So the date of patent of the main application would be the date of patent for the patent of addition as well. So here the main application was an ordinary patent application which was filed on 15th of July 2008. So your 20-year period would be counted from this particular date, and thus the 20-year period would expire on 15th of July 2028. So I'm just showing you the relevant provisions. This is section 55, which says a patent of addition shall be granted for a term equal to that of the patent for the main invention. So as long as there is the term left for the main invention, that much amount of time would be left for the patent of addition also, which in a way, if you translate it, it means that it would have the same date of patent as the date of patent for the main invention. For question 10, you need to refer to section 117A, which provides what are the available sections under which an appeal could be filed. So if an application is deemed to be abandoned under section 21, you cannot file an appeal against that. For all other sections, you can file an appeal, which are provided under the options. The language of question 11 is straight away picked up from rule 24. So it says that the application would not be ordinarily open to public for 18 months from date of filing or date of priority, whichever is earlier. So in a way, this means that a patent application would be published after 18 months from the date of filing or date of priority. So question 12 deals with filing of a provisional application and asks you to determine what is the date for filing of the complete specification. The first option says that the applicant filed a complete specification after filing a form 4, so in a way extended time, and then file the complete specification. This is not allowed. Form 4 is only valid for section 53 and section 142, which deals with the annuities and extension of time. So you cannot extend the time limit for filing of the complete specification. For part C, please see that rule 138 has very specific sections to which it can be applied, where the time limit could be increased by filing a petition under rule 138, and section 9 has been excluded from this. So the only option that is left with you is the applicant filed the complete specification after 1 year, which is on 12 May 2012 under section 9 subsection 1. I'm skipping question 13 because it is no longer valid. The appellate board is no longer there, so I don't think the question like this would come. Question 14 deals with the register of patents as to what all it contains. This is provided under section 67. Question 15 deals with the various grounds that are available for grant of compulsory license, and out of the given options, only the option under A is the relevant option. All the other options are not relevant, and you could refer to section 84 subsection 1B. Question 16 provides you with the situation. So researcher has developed an idea. So how would you advise him to proceed? Obviously, you'll ask him to file a provisional specification before publishing it in a scientific journal or maybe disclosing it to the public. So that's option B is the correct option. For answering question 17, you need to refer to the language of section 21J. It provides all these three options under A, B, C. Question 18 deals with export of a patented product under a compulsory license to any country which does not have sufficient manufacturing capacity, and this is provided under section 92A subsection 1. And this section is only applicable to pharmaceutical products and not to the other options that are provided under A or C. Question 19 deals with term of patent. So section 53 subsection 4 applies here. A patent, once it completes its full term of 20 years, it cannot be renewed any further. So that is the maximum term that could be allowed. So question 20 deals with restoration of patent. This is provided under section 60. Read with rule 84, and you can file for a restoration of a seized patent on form 15, and the applicable fee for that is rupees 2400 or 12,000 depending on the type of applicant, and you can file a request for restoration within 18 months from the date on which the patent ceased due to non-payment of renewal fee. So this is the way you have to study. You need to remember the section, the rule, the form and the fee, and also the time limits that are provided. So just keep a note of all these related sections and rules and the forms when preparing for paper 1 as well as for the questions in paper 2. Question 21 deals with the requirement of submitting proof of right, which is provided under section 7 subsection 2. The question requires you to specify the time limit within which the proof of right needs to be submitted. So this is provided under rule 10. You need to submit the proof of right within 6 months from date of the application. Question 22 deals with the grounds for opposition under section 25(1). The answer A is quite obvious because the request for examination could be filed by any person interested, and thus this cannot be a ground for opposition because the provision for anyone to file a request for examination is provided under the Act itself. So it cannot be a ground for opposition. All the other three, B, C and D, are provided under the grounds available under section 625(1). So you need to read and see what are the different grounds that are available. Question 23 deals with the definition of an international application, which is provided under section 2 subsection 1 IA. An international application is one which has been filed under the Patent Cooperation Treaty. For answering question 24, let us see what section 3 provides. So if you closely see section 3C, it says it is a mere discovery of a scientific principle or formulation of an abstract theory or discovery of any living thing or a non-living substance occurring in nature is not considered as patentable subject. In a way, you cannot claim monopoly over such subject matter. So a discovery of a new galaxy would most likely fall under section 3C because all other sections that are being provided under the different options are not relevant for this type of innovation or discovery. Question 25 deals with the definition of capable of industrial application, which is one of the criteria under section 21J. Now, the definition of capable of industrial application is provided under section 21AC. So you could refer to that, and option A represents what is provided under section 21AC. So question 26 requires you to answer where an appeal could be filed. So section 117A subsection 2 provides that an appeal could be filed before the High Court, and this has happened after the new amendment which becomes effective because of the Tribunals Reforms Act of 2021, as per which the IPAB has been dissolved. So in question 27 there are 3 applicants for a patent, and the question very categorically notes that they are not bound by any contract. So the question requires you to evaluate the shares for the 3 applicants. So this is provided under section 50 subsection 1. If there is no contractual agreement amongst the 3 applicants, then all would be considered to have an equal undivided share. So each one would have 1/3 share in the pact. Question 28 straight away deals with section 66, which says that a patent could be revoked in public interest by the central government, and for this a hearing would be held. The patentee would be provided an opportunity to represent his case, and then if the controller is satisfied, then a declaration to that effect would be made in the official gazette and the patent would be revoked. Question 29 deals with the fines that would be imposed in case someone is falsely claiming that his product is patented. So this is provided under section 120, in which a fine of up to rupees 1 lakh is imposed on that particular manufacturer who falsely claims that the product is patented. Question 30 deals with a situation wherein you need to determine the term of a patent, wherein you have filed a national phase application derived out of an international application. So particularly for national phase applications, the date of patent is the international filing date, which is 5 July 2012. And this is provided under section 53 subsection 1 explanation. So here date of filing of the provisional application is not relevant for that purposes because you have already filed an international application. So your date of patent would be from the international application date. Had this been an application filed under Paris Convention, the date of patent would have been the date of filing of the Indian Convention application. So whenever you file the Indian application, that would be considered as the date of patent for counting the 20-year term. So next is part B, in which each question has 2 statements and you have to judge whether one of the statements is true or both of the statements could be true or both the statements are false. And you have to answer A, B, C, D accordingly. So question 31 is straight away picked up from the language of section 59 subsection 1. And it defines what are the conditions which need to be satisfied for allowing amendments of a patent application. I have also made a detailed video on amendments under section 57 and section 59. You may refer to that video to understand the provision in a better manner. Question 32 gives you 2 situations wherein a researcher has published his invention. In one situation he has published it before filing of the patent application, and in the other situation he has published the subject matter in an international journal after filing the patent application, and it requires you to evaluate which of the patent application would not be refused. So out of the given 2 statements, statement 2 is correct, and this is based on section 13 subsection 2. You need to file a patent application and only then publish your innovation in any other journal. If you have published your subject matter prior to filing the patent application, it would be objected under section 13 subsection 2, as being anticipated. Question 33 relates to the provision of review of decision of the controller, and this is provided under Rule 130 sub Rule 1, and you can file for a review on Form 24 within 1 month from the date of communication of the decision. Thus, statement 1 is correct and 2 is incorrect. Question 34 gives you a situation wherein an Indian application has been filed taking priority from 2 US patent applications. So in principle, you can claim priority from prior existing two or more patent applications. There's no bar to that effect, and thus statement 1 given under the question is incorrect. And in a situation where you are deriving priority from 2 earlier filed patent applications, the priority date of the Indian application would be that of the earliest priority date, and this is under section 11 subsection 5. Thus statement 2 is correct. Question 35 relates to section 10 subsection 5, and it says that the claims of a complete specification should relate to a single invention or to a group of inventions that are linked together to form a single inventive concept. Thus both the statements are correct, and thus option D would be the correct answer for this. Question 36 relates to the power of controller, and this is provided under section 77 subsection 1, and both the statements under 1 and 2 are supported in section 77 subsection 1 part A and part G, and thus both the statements are correct, and hence the correct answer is D. Question 37 relates to the request for examination, who can file it. Statement 2 says that the request for examination has been filed by a third person. This is allowable under section 11B. Any third person who's interested person can file a request for examination. Now coming to statement 1, it says that the request for examination could be filed by either of the joint applicants. I did not find any support for this in the section or in the rules or even the form. So it says the applicant and doesn't specify that in case of a joint applicant, the request for examination could be filed by either of the applicants. What statement 1 says is incorrect as per my opinion. The request for examination would have to be filed by the joint applicants together and not independent of each other, and thus only statement 2 is correct, and thus the answer would be B. Question 38 relates to a situation wherein a biological material has been used in respect of the invention, and what is required under section 10 subsection 4 2A is that the biological material needs to be mentioned in the specification if it is not available to the public as such. The provision provides that if the applicant has mentioned a biological material, then he is required to submit that biological material before an international depository authority before filing the patent application in India in which that reference has been made. So if you read section 10 subsection 4 2A with rule 13 sub rule 8, you will be arriving at statement 1, which is the correct statement. Statement 2 is an incorrect statement, as it states that the applicant is not required to deposit the biological material. Question 39 relates to surrender of patents, which is provided under section 63 subsection 1, and you can surrender your patent at any time after the grant, and there is no specific time limit. Question 40 relates to patent of edition. This is provided under section 56 1B, and you can read the two statements and verify that this is what is provided under section 56 in respect of patent of edition. Now part C has a set of 10 questions which are again multiple choice questions, and in which more than one option could be correct. Question 41 requires you to list out the national or regional patent offices which can grant a patent. So out of all the given options, WIPO is the only entity which does not grant a patent as such. So there is nothing like an international patent which is being granted by WIPO, and this is the basic understanding of a PCT application. It is only a filing procedure. All other entities mentioned in A, C and D are intergovernmental organizations which can grant patents. So these have been recognized under section 133 as convention countries, and by way of the notification that was given by the government on 20th of May 2003, and you could refer to the BEAR Act where this notification is provided. So all these organizations are recognized as convention country under section 133, and section 133 provides that these convention countries are those which provide a reciprocal treatment to the citizens of India in respect of grant of patents in addition to other activities related to patent applications. Thus the correct options for question 41 would be A, C and D. Question 42 relates to the practice by non-registered patent agents, and this is a provision which is under section 123 of the Patents Act. It defines the fine that is applicable in case a non-registered patent agent practices before the patent office. So straight away from section 123, the correct options are C and D. Question 43 requires you to answer which treaty is India a member of. So India is a member of both the PCT as well as the Paris Convention, and thus option C is correct. Question 44 relates to division of application. It provides different options. So a division application could be filed before grant of the parent application. Then the applicant can request for an oral hearing to convince the controller that the invention comes under a single inventive concept. So if the objection has been raised in respect of the parent application, then you could request for an oral hearing and try and convince the controller that the concepts that have been claimed in the parent application relate to a single inventive concept, and thus a divisional application is not required. In the event he doesn't agree, then you go to option A and file a divisional application before grant of the. Also, if you do not want to file a divisional application, you could forego the second invention or the invention that is being objected by the controller as a distinct invention under section 10(5). Option D is incorrect because you cannot file a divisional application once the patent on the parent application has been granted. So option D is incorrect, but A, B, C are correct. Question 45 is directly based on section 6. It says that a patent application could be filed by the true and first inventor, the assignee of the true and first inventor, or the legal representative of the true and first inventor. Question 46 again relates to appeals that one could file under section 117A. Again, section 21 of the Act, I've already explained, is not an appealable section. All other sections you will have to remember as to what are the sections that are appealable under section 117A. So based on that, options A, C and D are the correct options. In question 47, you need to identify which are the non-patentable inventions. So a surgical instrument as such can be patented. It doesn't fall under section 3I because that is only pertaining to a method of treatment. Option B relates to a computer program per se, which is prohibited from being patented under section 3K. Again, discovery of any living thing is not allowable. Now, option D is a clock having 10 hours and each hour is divided into 100 minutes. Now one could argue that this type of clock is not known in the nature, but you never know. This might be a new innovation that might be useful for some innovative purpose. So as such, this type of clock would not be considered as non-patentable under section 3, and thus option D, in my opinion, would not be the correct option here. Question 48 requires you to identify the different modes of revocation of patent under the Patents Act. So option A and B now no longer stand because a revocation could only be filed before the High Court. Option B is obviously incorrect because a revocation cannot be filed before the District Court, but earlier it used to be filed before the Appellate Board, and thus A is no longer valid. A revocation application could now be filed before a High Court under section 117A. Also, revocation by controller is allowable under section 65, and a patent could be revoked by central government under section 66. Again, I have made a video on different provisions related to revocation, and you could refer to that video. Question 49 relates to the rights of a patentee provided under section 48, as per which the patentee has an exclusive right to prevent the third parties who do not have his consent from making, from selling, and from importing the patented invention. Question 50 relates to restoration of patents and opposition that could be filed in respect of that. So if a request for restoration of a patent is filed, it could be opposed by an interested person on the grounds that the failure to pay the renewal fee was not unintentional, that the patentee intentionally did not file the renewal fee, and that there has been an undue delay in the making of the application for restoration. The grounds provided under option A and C are the incorrect grounds, and thus options under B and D are the correct ground. You could refer to section 61 subsection 1 to answer this particular question. So this is all about the solution set for paper 1 of 2018. In case you have any further questions or have any doubts regarding the solutions that I have given, please feel free to write down your comments or questions in the comments box, and I'll be happy to answer those. Thank you very much.